right, good afternoon, everyone. Thank you very much for joining our CCPL seminar. It brings me great pleasure to welcome Professor Matthew Dyson to the Faculty of Law. Professor Dyson is a civil and criminal professor at the University of Oxford and also a fellow at Corpus Christi College. He is very well known. His work is very well known amongst criminal law scholars and amongst tort scholars. So he has this rare quality of being a very well-regarded scholar in both disciplines, crossing the civil and the criminal divide. He is also very influential in the context of cases that have gone to the English courts, particularly the case of R versus Jogee, which significantly transformed the law of joint or accessory liability, secondary responsibility in the UK. And I think many in Hong Kong know that the issue of whether we would follow Jogee came up in around 2016 in the quarterfinal appeal case of Kam Shing. And of course, we had said no, not the only time. In fact, one of several occasions when our quarterfinal appeal has been asked to follow the developments in the UK and has said no. Of course, it was somewhat critical of the English decision in Jogee, because as many of you know, as the judgment talks about, when people get together to commit a crime, sometimes it happens that one of amongst the group might commit another crime, a more serious crime. And the quarterfinal appeal referred to this situation as a situational uncertainty. And hence the doctrine of extended joint enterprise had been developed to deal with this. But in the context of the UK case of Jogee, the Supreme Court there applied a doctrine of conditional intention to deal with this type of situational uncertainty. And that reasoning, of course, was criticized in the quarterfinal appeal decision. So we're very happy that Professor Dyson has been thinking very intensely about these issues and has come all the way here to talk to us about some new thinking as to conditional intention. And hopefully we'll change our conditioned thinking about criminal fault. So Professor Dyson, the floor is yours.
Thank you very much, Professor Young. It's a real honor to be here, and I'm very grateful to the university for hosting me. It's lovely to be in Hong Kong again, and particularly my colleague, Professor John Murphy, kindly arranged part of my visit. It's true, I should disclose initially that I was an academic advisor in the case of Jogee, so obviously you might expect I have particular views on the case. I would also note that the judgment didn't follow all of my views, so I'm also entitled to criticize it. But what I'm actually hoping to do today is to talk a little bit about what I've called conditioned thinking about criminal fault. Now, that is, in my own self-indulgent way, a pun, because I'm also referring not just to the idea of conditional intention, but to the idea that we start to think in particular patterns. Our thinking gets conditioned. And to me, that's some of the most interesting of what we're doing here. So I might or might not agree with Professor Andrew Simister's views on how to justify extended joint enterprise or parasitic accessorial liability. I may or may not agree. But what I really want to do is work out why it is more likely to be agreed with or disagreed with by particular people. What are the values or the reasoning processes underneath it, which are attractive to some and less attractive to others? You should hopefully have a handout. The handout highlights that I'm going to be talking not just about some things in the common law tradition, but also some examples from civil law. And I've made 6 headline points, and I've extracted some text from the judgment in the case which you will have seen in the advertising, which also has the citation in it, and which was just referred to by Professor Young. Now, the 6 points I'm making are first to briefly introduce complicity liability as a setting for this discussion. It won't be the only setting. Second, to talk about conditional reasoning across criminal law more broadly, and I've given you one citation to a conspiracy case in the UK, particularly in 2006 under our House of Lords before it turned into the Supreme Court. I then want a bit of a theoretical discussion about conditionality and possibility. Fourth, some ideas here about what conditional fault standards, particularly conditional intention, is trying to do within the criminal law, and how my views on this differ from some of those published by other theorists. At number 5, I want to introduce some points about German criminal law and a criminal law doctrine common in many other legal systems in the world, perhaps the majority. And finally, a few reflections on what the conditions on our reasoning are and what we might learn from those. So I turn first then to number 1, complicity liability as a setting. Complicity liability is hard. I know those who are undergraduates, if you're any in the room, are getting some excellent lectures on it from Professor Jackson, but it is not an easy thing to understand. Now, in particular, it's difficult because it's one person's responsibility and culpability in respect of another person's crime. So all the normal calculations of one person's crime effectively get squared, get multiplied by themselves. It's also difficult evidentially, because it's very hard to work out who did what and who spoke when in many of these fact patterns. And it's difficult morally. How much should you be your brother or sister's keeper? The law has done its best to navigate that difficulty. I'm not sure any legal system I'm familiar with has done it in a way that I think makes complete sense. And in some instances has introduced greater complexity. But I'm familiar with at least some legal systems, for instance, in Victoria in Australia, where in a claim to reduce complexity, they have simplified the law in a way that expands liability dramatically. So sometimes complexity is used as a word to suggest the opposite of expansive scope. Now, complicity liability in the history of the common law tradition has had 3 forms, the first of which tends to be the simplest, sometimes called basic accessorial liability, sometimes just called complicity, sometimes called secondary participation. But in all instances, it's the companion to simple principalship. So who are the participants in a crime? The person who in some sense brings about the actus reus, or the physical components of the crime, and the person who assists, encourages, or in the older language, aids, abets, counsels, or procures. Some legal systems don't follow that version and treat all parties to a crime as equal participants. There aren't many of these unitary systems, but there are some. That's to say that as soon as you're involved in a crime in any way at all, you'll be treated in the same way. We used to have that rule for the most minor of our crimes, misdemeanors, and the most serious of our crimes, treason. Essentially saying, if you're involved in a treason, since it's so terrible, the slightest involvement is enough to make you a participant. And for misdemeanors, because they're so small, the slightest involvement was enough to make you a participant. So exactly the same outcome with the exact opposite reasoning. English law and most common law traditions have adopted since the early 19th century. 1848 is the first piece of legislation I found, but it's now in an act of 1861 in England, the Accessories and Abettors Act, of treating the participants for the purposes of trial and sentence as if they were the same. That does not mean they are actually the same. So there can be different substantive requirements to decide whether somebody is a principal or whether they are an accomplice. But for the purposes of processing them in a court and the outcomes that they receive, they are the same. A way to think about that is to determine whether somebody is the principal, you have specific requirements. For instance, for murder, that the principal would have to intend to kill or intend to cause grievous bodily harm and kill. But the accomplice doesn't need to do those things. Instead, for instance, they would assist the principal in doing that and have a particular mens rea state required, which does not need to be intending to kill or intending to cause grievous bodily harm. So your gateway to liability is slightly different. You either carry out the actus reus and mens rea of the principal, or you carry out the actus reus and mens rea of the accessory. But once you've gone through that gateway, for the purposes of trial and sentencing, the outcomes are the same. So we mirror what a unitary system does for trial and outcome, but have a separate substantive entry point. English law for many years required a felonious intention to take part, not an intention that the crime be carried out, but an intention to play some role in it, to be part of it, to assist in it, or to encourage it in the modern language. There were some technical difficulties, however, one of them being that the accessory could not be tried until the principal was convicted or outlawed. And secondly, that the secondary party or accomplice could not be liable for more than the principal. These were essentially trial restrictions, not substantive restrictions. The solution that the common law came up with in the 1700s was to deem anyone who is an accomplice and present at the time as a principal in the second degree. So upgraded a secondary participant into being treated as if they were a type of principal. The underlying logic was that if you were involved in a common purpose and present, you intended any crimes within that purpose, and it didn't matter whose act did them. You can see there the clever little trick to address the responsibility and culpability in the crime of another, because you were responsible, didn't matter whose act, and you had fault because you intended those crimes within the purpose. This common purpose rule faded out in England in the 1970s when, by various statutory rules, we removed the procedural distinctions which had made them necessary or at least useful. So no longer can the secondary party only be liable for the same crime as the principal, and no longer must you convict the secondary party you may only convict the secondary party after convicting or outlawing the principal. So we no longer have a substantive set of rules which relate to common purpose. There's no magic, substantive magic, in the idea of a common purpose in English law anymore. And there hasn't been for a long time. However, prosecutors routinely still allege the same arguments, the same narrative that would have been used in a common purpose case. They say that all the parties were in it together. You might wonder why they would choose to argue something which is more than they need to show, which I'll come on to in a moment. Why do they need to show, why do they choose to argue that all the participants wanted the crime to happen, which is not a requirement in the law? Well, as far as I can tell, it seems to be because it makes a persuasive narrative in front of what will mostly be jury trials. These are not like you, good members of the jury. These are people who wanted crimes to happen. So the idea of a substantive rule of common purpose has faded out a long time ago, but the narrative that accompanied it continues to this day. So that's the first two forms, accessorial liability and common purpose liability. The third form grew out of the second, some sort of extension beyond the actual crimes as agreed as part of the common purpose. There's an interesting story about how we got there, which I don't really have time to talk about. But the idea essentially becomes, once the criminal law started caring about your substantive mental state, actually asking, what were the crimes you intended that were part of your purpose? That story included a period in the early 20th century when we started to consider not just what your purpose was, but in fact, what you had foreseen and carried on anyway doing. Now, in the 19th century, you were taken to intend the natural and probable consequences of your actions. So we didn't actually look into, in most cases, what you personally had as your purpose. But come forward to the 20th century, and we start to ask subjectively what your purpose was, including as evidence of that purpose, those things that you had foreseen and carried on with anyway. But the real shift happened in a Hong Kong case of Chang Wing-Siu, somewhere between 1965 and that case of 1984, we hardened a rule that extended beyond your common purpose. We extended to include those cases where you had foreseen the possibility of an outcome and carried on anyway. So it was no longer that that possibility was being used to define your purpose. It was used to define those things which were also inside the scope of what will make you liable for, but not things that you could call your common purpose. This much, I think, is relatively uncontroversial. Some of my colleagues might disagree about the exact date when we expanded this new form, this extended form, or this parasitic accessorial liability form. You could have a debate about that, but it was certainly solidified in Chang Wing Siu. Fast forward for 30 years, we've had 30 years to apply this rule, and the Supreme Court of the United Kingdom in Jogee, the first time it's ever heard a combined case between the Supreme Court and the Privy Council, with a case called Ruddock from Jamaica, removed parasitic accessorial liability. So essentially what they said was, for every crime that you are to be charged with, either you're a principal or you're an accomplice. And if you're an accomplice, for each crime, you must assist or encourage it, and you must intend to assist or encourage it. So that removed two parts, and it's strangely often forgotten that parasitic or extended joint enterprise had two limbs to it. One was, you haven't contributed to the second crime at all. Merely in committing one crime, a further crime arises and you foresaw that crime as possible. You haven't done anything towards that crime. You haven't lent a knife, you haven't given an instruction. So that lack of responsibility was one limb. And the second limb was, you merely foresaw that it was possible that that crime might be committed, which is, though it was contested by one of counsel for the respondents in Jogee, it is, in fact, the lowest subjective fault element English law recognizes. And in fact, I can't think of a legal system which recognizes a lower fault element than mere foresight. You could argue that a subjectivized negligence, which some civilian systems use, is akin to that, but it's not a subjective fault. It's just that the person could have lived up to the reasonable person standard. So it's more like a gloss on capability rather than on mental state. So far I've walked you through the position we got to in England. There are pros and cons to it. Of course, as you have already heard in Kam Shing, the Court of Final Appeal here rejected that outcome for Hong Kong law. Now, conditional intention within this, moving on to number 2 on my handout, is a part of English criminal law and has been for some time. But the role it plays depends on other factors, particularly the definition of fault elements that you use elsewhere in the law. So if you have an expansive definition of fault for intention, you don't need, or at least you wouldn't, if you were a prosecutor, turn to call for conditional intention. So in the 19th century, you would take into intend the natural and probable consequence of your actions, but also, even as far as 1843 in one of the Criminal Code Commissioner reports, the idea of mens rea included not just your purpose, but those things you foresaw as probable. So there was a quite expansive definition of purpose in the 19th century. And if you have foresight of a probable consequence as counting as mens rea, you don't normally need to talk about conditional intention a great deal. We have talked about it in other areas of the law. Classic case of Psych, which was a conspiracy case to handle stolen property, particularly money, in respect of cash transactions. There was a valiant attempt, which I've given you the paragraph reference to, paragraphs 20, really mid-20s to 36 in the judgment of Lord Nichols, where he considers an argument from the originally prosecuting counsel that a person who foresees that the money he deals with might be stolen, but carries on anyway, conditionally intends to handle stolen property. Technically, the argument was that a person who suspects goods might be stolen and who carries on to handle them conditionally intends automatically that he handles stolen goods. Now, this argument to me is factually quite often perhaps true. Somebody who first suspects might then make a choice that I will carry on anyway. But on the other hand, it is not logically the case that all instances where someone foresees a risk and carries on automatically mean that that person intends that outcome. It's almost impossible to argue that, and I don't really see how anyone does so seriously. There's an interesting example about that in Chang Ming-Siu, which was picked up by the latest cases in Hong Kong, where Sir Robin Cook said that if you foresee something and carry on, it is akin to authorizing that thing. But this we resiled from within a few years, because foreseeing and carrying on doesn't mean the same thing as authorizing. If I foresee that if my tone of voice carries on in a very slow and soporific fashion, that you might fall asleep, and I carry on anyway, does that mean I've authorized you to fall asleep? No, the answer is not that I have authorized sleep on your part. Also, there's an authority paradigm inside that I might have the authority to decide what to authorize on your part. Linguistically and logically, it doesn't follow, and so hasn't been argued for some decades in England. I might be wrong, but I struggle to understand how it would be otherwise. Lord Nichols rejects the argument and says, well, that might be very similar. It might be morally as bad, perhaps, but it's not what the law was in respect of conditional intention and conspiracy. So conditional reasoning throughout the criminal law does exist. The question is, how much do your fault elements raise it as a possibility? If you accept recklessness, foreseeing a risk and carrying on unreasonably to take it, as defined in English law now, then conditionality doesn't usually raise its head, because so long as you foresee the risk and carry on, that would be sufficient. You don't have to ask about the conditions. Moving on to number 3, what do I consider conditionality to be doing? It's difficult to conceive of a world without conditions. There are very few things in our lives where we would say, come hell or high water, this is what I will do. It is possible to think of some, perhaps. It's a bit like the flip side of every person has their price. At a certain point, you might say, well, I would give way to this argument. But even our conditions about tomorrow, that I have to get a flight tomorrow, well, not if there's a tornado, not if there's a tropical storm, not if there's an earthquake, as the US recently experienced, let alone elsewhere in the world. There are all kinds of conditions built in, which I may or may not be referring to. But ultimately, the test that we use for conditionality is to ask, at the point of making a decision, did this defendant accept as part of their purpose a thing that they would otherwise not have accepted? So conditionality is a way to accept two otherwise difficult or irreconcilable statements. For instance, that the robbers did not want to kill a security guard, because in general terms, robbery is bad, but homicide in the course of a robbery is much worse, both morally perhaps, but also in terms of the sentence you're likely to receive. So it's not that difficult, I think, to accept that there might be a criminal who, while willing to commit robbery with weapons, does not want to kill. But at the same time, to accept that there may be situations where that desire not to kill will fall away. So we acknowledge that that individual normally does not want to kill, but might accept killing for a certain reason or purpose. So conditional intention is a way to accept inside a purpose things that are not normally there, or to put another way, to accept that this person normally wishes not to do the prohibited thing, but there might be reasons why the person would. And we see this in the language of only if and even if, which to me are just flip sides of which direction you're traveling in. The defendant would, in the case of the robbery example, only kill if, or would kill only if necessary for the robbery. So if you start from the collateral outcome that would normally not be desired, and then end up with the purpose, you use only if. And if you spin them the other way around, you get the even if formulation. He wants to commit the robbery, even if that means killing. So it just depends which direction you're traveling in for the purpose and the collateral outcome. Now, some of my colleagues have done very impressive pieces of work. I'm particularly thinking of two pieces by John Child. I've cited you one where he worked with Adrian Hunt, and a piece by Andrew Simister, arguing that conditional intention is in effect a red herring. At the point of acting, the defendant must have resolved any conditions. What this effectively means is the conditionality is, in the way I'm thinking about it at least, a sop to the facts. It's an acceptance that these facts are in the background, but practically they are irrelevant. So we acknowledge, defendant, that you would not normally wish to kill, but at the point you acted, you accepted an intention to kill. There is a lot of merit in that argument that at the point of acting, the defendant had decided. The difficulty I find with this is that it is very easy to assume that the defendant must have made a choice, because this logic does require a choice. It's not mere foresight. It's not a cognitive, cognitive element of a foresight of a possibility. It's a conative element expressing your purpose to take a choice, to make a choice and accept outcomes. So for instance, when I asked just before this talk began, how long do I have them for? How long before they can start asking me questions? One version of that answer is, well, you have, let's say, 45 minutes. Did I time my talk to end at exactly 45 minutes? We'll find out, but let's assume for a moment I didn't. Did I worry in advance and say to myself, well, what time will it finish at? Will I overrun? Or did I say, I'm not going to make a decision to include this point or exclude that point. I will continue and read from their faces how much they understand about what I'm saying, and I might need to interpret, add more detail in particular places. Would you say that I conditionally intended to finish late? I didn't make that choice. I didn't cross that bridge when I would come to it yet. Now, I like to run this example a bit more practically by thinking about the reasons why you might foresee something but not actually conditionally intend it when you carry on. There are 5 such reasons. The first of them is the first 2 of them relate to personal failure. So one is you foresaw a possibility, but forgot at the point you were making a decision. The second is related, but slightly different. You hadn't forgotten, but you hadn't connected it. A bit like double booking yourself in a diary. You had 2 obligations applying at the same point in time. You just hadn't realized that they connected with each other. The third possibility is a bit different, but that you dismissed its likelihood. So it's not that you didn't remember it. It's not that you didn't connect it. It's that you actively made a choice about how likely that possibility was and dismissed it. But you still acknowledged that it was a possibility. You just didn't think it would happen. So you've made an evaluative choice and dismissed its likelihood. The fourth possibility is that you haven't engaged with it because you have focused predominantly on your purpose. And the fifth possibility is your purpose, as it appears in the eyes of the law, for instance, commit the robbery, is actually a means to an end for you. And you're focused on getting the money that the robbery is there for in order to afford the fancy car, the medical treatment, whatever the story is. I can run this example for you in a slightly different format. I'm lucky enough that tonight I'm going to go to dinner, and a friend has told me that my sworn enemy will appear at the same bar that we're going to start at. When I decide later today to go to the bar, I've forgotten that my sworn enemy will be there. And as a consequence, you couldn't say I conditionally intended to see my sworn enemy. Or I just happen to realize know the two things are true, but not connect them. Third possibility, my sworn enemy shouldn't be in Hong Kong, right? Everybody knows my sworn enemy is actually in Kuala Lumpur. No, somewhere very distant. And so I think the possibility, though I was told by a friend that it might happen, I think the chances are very, very slim. The fourth possibility, I'm focused on getting to the bar because I really want to drink. And so you tell me, oh, Jimmy, Bob, Jemima might be there, and I'm not focusing on that. I'm not really paying it any attention. It's something that may or may not be true, but my cognitive processes and my conative processes are focused on the purpose, which is going to the bar. And the final example might be that in the most wonderful way possible, I would like to get over my enmity with this individual and not think of them when I live about my daily life. So it may or may not be true that they're there, but their being there is not part of my decision making, because I would like to run this exam. I would like to live my life without reference to where my enemy is. So those are 5 ways that you could have conceived of a possibility, but not then intend it, even though you carry on. All can be applied in the context of a criminal enterprise to commit the first crime as well. What alternatives are there to talking about purpose and risk-taking? Well, some legal systems don't do what English law has done. In fact, they do what we used to do, and for some reason we stopped doing, which is to say, with inside purpose, they include deliberate risk-taking. And this is the example of dolus eventualis, which is sometimes, and I think erroneously, translated as conditional intention. It's the model in Germany and in many civilian legal systems. Dol eventuel in France, South Africa has it too, Spain, Italy, and so on. Here, instead of something being your direct purpose, and there are a number of forms of this and some theoretical debates, but to take sort of the paradigmatic form, X outcome is not your purpose, but you have foreseen it as a substantial or significant risk. It's not a tiny risk and it's not a certainty, it's a substantial risk. And you've demonstrated that you're willing to take that risk. So here it steps from first a cognitive analysis of how likely the risk is, substantial. I don't have a number for you, 30%, 40% certainly, 20% maybe, but probably not only 10%. There's some number where you might start with what substantial means. And then we need some sort of evidence, cognitively speaking, about how likely it is, sorry, not how likely, about how much you've accepted that outcome, however likely it is. So it could be something that's substantial, not very likely, but substantial, but you really accept it as a possibility. So for example, if we take a 6-barreled gun loaded with 2 bullets randomly and spin the barrel to point at a friend who we love, if we pull the trigger, did we intend to kill? No. Did we intend to cause grievous bodily harm? No. We were doing this, I don't really understand, but let's assume for some sort of thrill. A 1 in 3 chance that the chamber that was loaded, sorry, the chamber that rotated into the barrel was loaded. That's a substantial risk, most likely. And by pulling the trigger, you demonstrated you were willing to take that risk. This brings into offenses which accept that form of fault. So not all offenses inside a number of legal systems that use it accept dolus eventualis. But when they do accept it, they treat it as if it were intention. So they would say of this person, you have a form of intention in what you did. So this intention connects to the possibility of something happening by saying you were willing to take that possibility. Now, you might wonder how you test for the willingness to take that risk. And I must admit, I find it very hard to understand how, for instance, German law does this. And I haven't really found a convincing explanation. In a recent case about night riding, essentially speeding in large motorways inside a city in Germany, putting a seat belt on when you're driving at hundreds of miles an hour, 100 kilometers an hour inside at 2 a.m. Putting a seatbelt inside the city, putting a seatbelt on demonstrated you were aware of the risk that you might crash, carried on speeding, but kept the seatbelt on. Now that's one way of looking at the case. The court itself seemed to downplay the role of the volitional element in this, but in practice, that was the evidence they had. Now, this is sometimes translated as a conditional intent, and I don't think that's correct. And the reason I don't think that's correct is, in the way I understand conditional intention, you are assessing the mental state and saying this person made a choice to accept an otherwise undesirable outcome as a condition of the outcome that was the purpose, the outcome that was desired. Whereas dolus eventualis doesn't only include that choice to subsume with it or for the sake of a purpose. Instead, it covers people who just don't care enough about others. the sociopath is included within dolus eventualis without having made a choice that the robbery, for instance, was important enough to accept a killing. That person just doesn't care about killing. Now, that may well be culpable on its own, but it's not conditional in the sense that the killing is in some sense necessary for some other purpose. So while they overlap significantly, dolus eventualis is broader, particularly because it doesn't require actual conditionality. This is the way I understand it. Now, some of my colleagues disagree, but at least this makes sense of the distinction between the two. But what I'm highlighting is, if you use something like dolus eventualis, you won't need to talk about conditions very often. So many legal systems have the possibility included inside their mens rea states, whether it's an intentional state, potentially, or particularly a reckless state, and even a negligent one. And even inside English law, we have expressly considered conditional intentions within complicity and in other places in our law. The language of they were in it together, they intended the entire process, is a way to avoid having to expressly talk about conditions for that process. Now, I've included on the handout some material drawn from the case in Hong Kong, Kam Shing, and I don't actually want to talk about it in great detail, but I will just quickly walk you through it. It will be obvious to you that I'm using this to answer number 6, which is what are the conditions on our reasoning? It seems to me that the implicit statement here is that there is no separate status for a conditional intent inside the law in Hong Kong. The logic here, if applied to its natural conclusion, there cannot be conditional intentions in Hong Kong. Now, that isn't what's expressly stated. This material denies the value of a conditional intention inside complicity rules. But the logic would deny any place for conditional intention at all. I put out paragraph 58 of Justice Ribeiro's judgment. He says that I don't agree with Jogee for 3 reasons. I've then summarized these as the culpability reason, the gap reason, and the conditional intent reasons. Obviously, the conditional intent reason is more interesting to me for present purposes. I'll briefly mention the culpability reason. I put out paragraph 60 and 61. He says that he does not agree that the secondary party is in some sense less culpable than the principal. I haven't entirely understood what values are at play here, because it is possible to consider, as he indeed does, a case where the secondary party is in a sense more culpable. The Moriarty in his web instructing his relatively simple-minded thugs to commit crimes is perhaps more culpable. And the example he gives is Lady Macbeth, which was an example from Gamble Williams. But of course, those are examples where the principal commits a crime, it's true, but the accomplice is the one who procures it. So it picks out specifically procuring as the example, not assisting or encouraging. And it specifically picks up places where the accessory intends the crime to take place. Those are not cases where the accomplice merely foresees it might. They don't seem to be very strong cases for justifying a rule which is based on foreseeing the crime will take place. Now, if they are cases where you say there's not necessarily a lower level of fault, that's true, but their fact patterns suggest, to me at least, with the values that I understand, that they are limited to the places where the secondary party intends the crime to take place, which is not the rule that was being agreed upon. Second, that there are gaps. This requires an understanding of what Hong Kong law uses for common purpose liability. If it still exists here, I don't know. I don't claim to understand that in any detail. I can only explain that it doesn't in England anymore, and that was part of what Jogee's reasoning was about. The paragraph 62, I've noted that His Honour says, I haven't included the authorities, but as the authorities cited above show, the liability of a party to a joint criminal enterprise is not derivative, but arises independently by virtue of his or her participation in the joint criminal enterprise. So that is conceivably true under a logic of common purpose. If you use the idea that each act is done as if by my own hand, then you're responsible for each of those acts, and it might be primary liability. You are using a fiction, but you can describe it as such. But if by definition, those in the extended common purpose are outside the common purpose, I'm not sure how you would say that those are things which you've done yourself primarily. You can make that argument, I suppose, but I haven't understood it. But if that was true, why is this introduced as there's a gap in the law of complicity? Because that wouldn't be a complicity gap. That would be a participation gap because it'd be primary liability. So I haven't understood why this is complicity. He mentions that he can't see this as constructive liability. Now, I think I agree with him there. If you say that the fault is that you must foresee the possibility of a crime, that is not constructive, because constructive would normally mean fault in respect of a harm is being constructed upon for a greater harm. What it is demonstrating is it is a much lower fault component. For instance, in homicide, intention to kill, intention to cause grievous bodily harm, foresight that another person might kill, intending to kill or cause grievous bodily harm. Foresight is a much lower mental state than actually having that as your intention. I've noted I haven't understood an argument about foreseeing and continuing as being equivalent to authorizing, and English law has moved away from that. Perhaps there's more that can be said to support it in Hong Kong. And he notes that intention can be hard to prove in dynamic violence cases, and therefore murder will be hard to prove. And he raises the possibility then that Jogee, it's unclear how Jogee will allow for lesser offenses. It strikes me as potentially intention, the idea that the other rules allowed a conviction, the parasitic accessory liability rules allowed a conviction for murder more easily because it was evidentially difficult. And so Jogee allowing a conviction for less is somehow a gap. I haven't understood that tension completely. But moving on to conditional intention, according to Justice Ribeiro, these rules were inserted by Jogee. I'm not sure that's true, but it is true that the language we had used previously in it together avoided the need to do so. And of course, until the middle of the 20th century, we wouldn't have really had a formulation that required this. So it wasn't until 1967 that we really firmly said you were no longer taken to intend the natural and probable consequence of your actions. Of course, it had been dying out earlier, but it had to be restated in 1967. I've given you the two quotes from Jogee. I don't want to read those out. But at 76, he notes first, isn't it interesting that in those three paragraphs, he included 94, which I didn't for this purpose, the idea of conditional intention is defined in the respect of a common purpose, but without describing a common purpose. I don't personally find that very surprising. First, because conditional intention is referred to elsewhere in the judgment without talking about common purposes. So I don't think it's specific to these three. He just has picked three where it is used. But also, as I've noticed, common purpose for us is just a factual description that they all intended the crime to be committed. It doesn't have any separate rules. It's just an expression of at least intending to assist or encourage. And then he discusses whether or not there's any difference. I don't have time to completely unpack some of this, but what it seems to boil down to me is that either he says you can't demonstrate factually that someone foresaw something and used the same evidence to then work out that they intended it, and or that by accepting conditional intention, you're doing something no different to just asking did they foresee it or were they reckless to begin with. The first of those is an evidential problem. My understanding of how criminal law works is that very often, indeed, as His Honour says, we don't know whether somebody intended an outcome. What we know is, from the evidence gained, we can accept that they must have seen that outcome and carried on. The question for the jury is then, understanding that they, the defendant, foresaw something, is it more than that? Did they actually intend it? And courts up and down England and Wales do this every single day. And they use the same evidence. I don't know how it works in Hong Kong. It may be that being able to persuade a jury for certain that the defendant foresaw something, you are then not entitled to say, members of the jury, we've persuaded you that the defendant foresaw something. We would now like to demonstrate that, in fact, he not only or she not only foresaw, but also intended. Look at these other points about the defendant's behavior. Look at the other evidence we can give you. Foresaw, then carried on, here does demonstrate that purpose. It may be that that's impossible here, I don't know. So ultimately, what seems to underlie what is the conditioned thinking here is that conditional intention is not useful and it's not valuable. This discussion took place in the context of rules which required only that you foresee the second crime might be committed. So when you have mere foresight, which is inherently a condition before you get to purpose, you can't have something as your purpose which you don't believe is possible. And to get to belief in possibility, you must at least conceive it as possible. Then there may well be no need for it in the sense that you can convict without it. But my interest here is in working out what the justification for the liability is. So within a parasitic accessory liability type situation, we have to accept that there isn't direct responsibility for the second crime. It merely arose in the course of the first. And we also have to work out then what is sufficient culpability. And to me, that seems to be the ultimate condition. The condition that's been accepted, at least in this judgment, is that it is enough that you consciously take the risk that another person might commit a further crime, that you are connected to the outcome of that crime as if you had done it. That to me seems to be a moral anchoring point, a choice that one makes. And I don't have any particular power to persuade or dissuade that that is a good or bad answer. All I can say is a lot of the rest of the judgment seems to me to be ways to step around that value choice, because on its own, it doesn't stand or fall through logic. It's just a choice about what risks you're connected to. So to conclude, what I want to do more of is work out which are the choices we're making that we don't think stand alone, and so we require further explanation to try to buttress, and which are the choices that we do encapsulate in our logic. For me, it's an impressive and interesting judgment, but what shines out most is that this conditionality doesn't seem to be acceptable at all in Hong Kong, because if it's not acceptable here, I don't understand why it would be acceptable elsewhere. Thank you very much.
Thank you, Professor Dyson, and thank you for keeping within your intention of allowing for some time for Q&A. If I may begin the first question. If I understand your definition of conditional intent, one intends to commit X even if Y should materialize. Hence, one intends Y. And it's because one has accepted that possibility. In that definition, it doesn't take into account in the mental process an assessment of the degree of risk or the degree of likelihood that the consequence would materialize. So what do you then say about the doctrine of virtual certainty, which we already accept as being a way of finding intention? Is your account sort of at variance with the virtual certainty? And then are you setting a lower threshold? That's one question. The other question I had for you is the issue which you haven't touched upon, is the question of timing. So you used the example about possibly meeting your sworn enemy at the bar. And then you there's 5 situations where there would not be conditional intent. But does it also depend on when you ask the question? Is the timing of what one has in one's mind important? And you haven't really touched upon that.
Thank you. Yes, I must say there's hours and hours of things I would love to talk about with you on this. And these are 2 things I haven't spent the time on. I can try to answer them quite quickly. I see zero problem with the virtual certainty argument in Woolen. Zero. Some of my colleagues do see a problem and made some hay about it in the immediate aftermath of Jogee. They would say, well, if we can use foresight as a means to find intention, why do we isn't this in conflict with the Woolen rule from 1999 on that a jury may, but don't have to, find that where a defendant foresaw X as virtually certain, and it was virtually certain, that the defendant intended X. Now, the reason I don't see any problem with this is, first, as I noted, this is the way that we deal with all intention cases in the real world anyway. This is not a different thing. And I don't understand how those who criticize this I don't know how they think intention is found in a normal court case. But the substantial problem is, well, two things about Woolen. One, it's almost never used in English law. There are, I mean, I've done a search recently. I found about 15, 18 cases which refer to it since 1999, none of which was significant. Only one applied it, and the rest were discussing whether it shouldn't have been used when it was, and all said it made no difference. So in practical terms, you can go your career in England without using it as a criminal barrister. It's not. Now, that doesn't necessarily have to be the case elsewhere, I should add, but just in England, for the judges who were deciding this case, it's not a live issue. But more substantively, at least the way I understand it, the jury are making a choice that even though the defendant, because you only give the instruction and why it's not used, where purpose doesn't do the work. So the first question the jury get asked is, did the defendant intend X? Are you sure that the defendant intended X? And that's it. We don't give them a definition. I don't know if you do in Hong Kong, but we don't. If they come back and say, we can't seem to apply this on the facts, then the Crown Court Compendium gives them the ability, gives the judge the ability to say, this is a definition of intention. It means purpose. If they still can't apply it, and this is the facts of Woolen, a man throwing his baby down in a world where he did not wish to kill his baby, then we're allowed to go this further direction, but it's not very common that purpose doesn't help us solve a problem. So in those very narrow circumstances, the jury are allowed to find that foresight of a virtual certainty is equivalent to. But even if they find the defendant foresaw something as virtually certain, they do not have to find that it was equivalent to intention in the circumstances. So the virtual certainty rule is a way to give the, in Horder's language, moral elbow room to the jury to decide that this is equivalent to intending, even though it's not the same thing. Whereas what happened in Jogee was you're finding intention. You're not finding anything equivalent to intention. You're saying the intention actually existed. You're saying the purpose actually existed. And so for that reason, there is zero conflict as far as I understand it. Now, factually, they might come close together, but typically not. And the other point about timing, I might have to think more, and I might not have fully understood. And sometimes this comes up because, of course, you can dismiss my first example as just saying you forgot. That means at one point you knew, but at the point you made your decision, you didn't remember that piece of information that your enemy might be there. Therefore, well, it's just a timing point. If you made your decision earlier when you remembered, you would have had to confront it. But what I'm interested in is, in any part of the criminal law, we might have decisions which you make at particular points of time which could trigger forms of liability. It could be that you load the explosive on the seat where you expect your enemy to sit some hours later, you poison the spoon. Or it could be when you send a missive to your friend instructing him to kill. There could be lots of things depending on timing. So I haven't seen yet why that matters, because all of those rules will turn on what particular crime we're charging you with. Now, in the complicity example, it could be something like, when I send the text message that tells my principal where the victim is, what knowledge did I have then? Well, for the purpose of complicity, that would be important then. Professor Simister has argued that it makes a difference. You can't call that conditional, and it can't. And Justice Ribeiro referred to the idea that it couldn't generate liability, while also the principal might be conditionally thinking about something. I haven't fully understood those points, because it seems to me that you can make your choice then based on the idea that person will go on and do something. If they don't, okay, it doesn't happen, but you've made your choice then. You have resolved your condition. Now, there are some tricky examples for this. I can give you one if you're interested, which is where you hire a private detective to spy on your partner who you think is cheating on you, but in fact is going to dance classes to surprise you at the next event, whatever, your birthday. You give the private detective the instruction to kill your partner if your partner is cheating on you. And your partner is not, but the detective kills your partner anyway. Now, you've conceived of a condition upon which your partner might be killed. So in some sense, you've conditionally accepted killing, but it was subject to a condition, like necessary for the robbery here. was cheating on you. Now, would that generate liability as an accomplice? I think my answer is, one, in terms of the condition that you've accepted, that condition wasn't satisfied. So this isn't, once you've accepted one possible world where this could happen, you're liable in any world where it does. But also, Jogee considered a thing called overwhelming supervening event, which separates out the principal from the accomplice. Withdrawal is the flip side. If you withdraw from a crime, you separate yourself out. And this is where the principal is separated by distance and time from the contribution. And I think the private investigator's deliberate choice to go against the instruction might well be an overwhelming supervening event. But our courts have done what I find pretty surprising things with that doctrine. They say it's not causative, for instance, which I haven't really understood their argument about what it is if it's not causative. Anyway, I hope that answers the question about timing.
So I think it's been a very fascinating discussion. I think we really could go on for a few more hours. Maybe we have to organize a conference around this topic. So please join me in thanking Professor Dyson for this very enlightening discussion.